Hey everybody, John Skiba here, and on today's video I'm going to talk about how to respond to written discovery requests that you receive from the junk debt buyer. So this is requests that they're sending to you and wanting you to provide documentation, information. I want to talk about some of the approaches to responding to this and some of the things that the debt buyers do to try to trip consumers up and have a judgment entered against them without even going to trial. But if this is your first time here to my YouTube channel, first of all, I really appreciate you being here. Over the last year, this channel has grown incredibly. Something I wanted to make you aware of. If you look down in the notes to this episode, you're going to see links to the various online tutorials that I've created that really do a deep dive in topics like filing and drafting an answer to a debt collection lawsuit, responding to a motion for summary judgment. One of our most popular ones is filing a motion to compel private arbitration to win your debt collection lawsuit. And I even have bundles where you can get the whole thing on how to deal with a lawsuit from day one until the case is over. Check those out. Those are really more of a deep dive than what we do here. I have templates, forms, and things like that that can help you with your case. All right, let's go ahead and jump into responding to written discovery requests. Now, I've done tutorials, I've done other videos on you sending requests to the debt buyer, to the plaintiff, the debt collector, trying to get information and documentation from them. But what you'll see is that they can also request information and documentation from you. And the three main ways that they do that is through written discovery, and they are request for production of documents, interrogatories, and requests for admissions. Now, it's important to look at the rules in your particular jurisdiction that govern these three types of written discovery. You're going to find these in the rules of civil procedure. Usually, they're going to be in rules 33, 34, and 36. If you go to Google Scholar, or if you go to the Legal Information Institute, the Cornell Law School puts all this information online. You need to look up the rules of civil procedure for your particular state, and you can even put written discovery. You can search for interrogatories, requests for productions, requests for admissions. You're going to see there the rules that govern these particular types of discovery requests. Particularly what's important is you're going to see how much time you have to respond to it. So if you're going through your case and all of a sudden the debt buyer, let's say you're dealing with Midland Funding, Midland sends you over requests for admissions. You're going to see in most jurisdictions you probably have 30 days to respond to it. But I have seen states where it's longer, where it's 40, and somewhere that's 20. It's vital that you find out in each of those rules, 33, 34, and 36. It may be different in your state as far as what they're numbered, but in most jurisdictions they're based upon the federal rules, and so it's 33, 34, and 36. You need to look at how much time you have to respond to it. Because when it comes to written discovery, if the debt collector, if the debt buyer sends those to you and you don't respond timely, there can be devastating consequences to your case. And I'm going to go into that a little bit later. Let's break these down one at a time. Let's start with how to respond to interrogatories. First of all, what is an interrogatory? Just a fancy word for a written question. This is essentially where the debt collector, the debt buyer, is sending you over a question, and it's just kind of open form. They want you to, they may be asking about specific information leading up to the debt, how the debt was incurred. They may have questions about what kind of documents you're going to use at trial, that kind of thing. So in responding to those, interrogatories, first of all, I don't see a ton of interrogatories in debt collection lawsuits. I tend to see more requests for admissions. But if they do ask an interrogatory, as long as the question is either focused on your case or is likely to lead to discoverable information, you likely have to respond to it. It is permissible to raise objections. If you feel like they're asking for something that's not permissible, like sometimes they'll ask for like a social security number, or if they're asking for banking information. Those things are not permissible during the lawsuit itself. If they get a judgment against you, they may be able to get that information. But at the stage where they're still just trying to prove that you have liability on the debt, personal information like that is generally not discoverable, and you can raise an objection to it. Otherwise, you respond as truthfully as you can to the question that they're answering, and then submit that back to them. Now, when we jump into requests for admissions, like I said, that's usually Rule 36, and that's what I see the most of, because this is where the debt collectors, junk debt buyers, so that this is often where their attorneys try to trip people up. Because, and let me tell you how these things are framed. It's usually essentially a yes-no question. It's an admit or deny question. So they'll have a question, and then there'll literally be like a little check the box underneath it that says admit or deny. And you have to state whether you admit or deny what it is that they're alleging in that sentence. Now, here's what they often do. You'll see kind of weird questions like, admit that you owe us $6,532. Next question will be, admit that we are the current owner of this debt. Admit that, that you're going to pay our attorney's fees. Things that you would never admit because you don't know, because you truthfully don't know, or that they haven't proven yet. The reason why they put those questions in there is because in most jurisdictions with requests for admissions, if you do not respond timely, all of those questions are deemed admitted. And so what I'll see is a lot of people aren't aware of this. They're not sure how they're supposed to respond to the request for admissions. They don't send them back timely. And then all of those questions that they have, they're deemed admitted. And then I see the debt buyer file a motion for summary judgment, attach that as an exhibit, and say, look, Judge, legally they've admitted all these things. They've admitted the amount owed. They admitted their breach. They admitted that we're the current owner of it just by default because you didn't respond to it. This goes back to what I always say with these things. Showing up is more than half the battle when it comes to debt collection lawsuits. Whether it's filing an answer or filing a response to the request for admissions, you need to be able to respond to those. And so you don't have to provide any additional information. Like when they say admit that we're the current owners of the debt, unless they've proven that and you know that independently, it's okay to click deny on there or check deny on there that you deny that that's true. If the dollar amount that they're showing is not something that you have independent knowledge of, you can deny that as well. You can also raise objections. With requests for admissions, generally what I see is sometimes they'll ask what's called a compound question. This is where they're asking multiple questions within the one numbered question. So if they're asking multiple questions, you can object to that saying it's a compound. There's more than one there. You're not sure which to admit or deny, so you just object to the whole thing. I usually check deny just to be on the safe side. So that's requests for admissions. Those are super important. At the end, I'll tell you if you run into the situation where you didn't respond timely, I'll tell you what you can do about that to still keep your case on track. All right, request for production of documents. This is usually under Rule 34. Requests for production, I don't see a whole lot of these just because generally they should have all the documentation they need. If they don't have the documents, they're in trouble. They shouldn't have filed the lawsuit in the first place. So it's tough to think of what kind of documentation that they would typically need from you because the monthly statements, all those kinds of things, they should have that information. Not only that, debt buyers, they're usually filing lawsuits several years after the account was charged off. And so most consumers that I meet with just don't have any documentation. Most people don't keep, credit card statements for years on end kind of thing. So I don't see that one as much, but if they do request documents that you do have in your possession that are central to the case, again, they can't ask for a copy of your social security card or anything like that, or your bank statements. I wouldn't provide those. But if they're asking for monthly statements and you happen to have those monthly statements, you need to provide copies of them and submit that to the other side. One little quick point is that discovery requests are not filed with the court and the responses are not filed with the court. These things are just done between the parties. So you don't need to submit a copy to the judge for them to take a look at. It only goes to the opposing counsel. So let's talk about requests for admissions though. What if you find yourself in a situation where you did not respond timely and those have been deemed admitted, and particularly if they're trying to use those against you in something like a motion for summary judgment? If you find yourself in that situation, you can file another document with the court and ask the court to withdraw those admissions. Essentially, you're saying, Judge, hey, I didn't quite understand the rule. I do want to respond to these. And you have to provide a legal excuse why it is you didn't respond timely to the responses for admissions. Usually that's called a motion to withdraw the admissions. In most circumstances, unless trial is imminent, I've seen that courts are pretty willing to withdraw those. They want the case to be decided on the merits, not on some technicality like that or some gamesmanship that you see the debt buyers playing in. So I hope that helps in responding to interrogatories, requests for admissions, requests for production. I'm in the process of building a deep dive tutorial on that particular subject. I've had a lot of people tell me they've struggled with knowing what to say and how to respond to that. So that'll be coming out soon. You can watch that. Otherwise, like I said, check down below in the notes below and you can see some of the other tutorials and courses that I put together. And with that, I appreciate you watching today.